All right, so Chapter 4, Torts and Cyber Torts. And we're going to talk about what a tort is, the different categories of a tort, zero in on negligence, which you've probably heard that term before, and even look at strict liability. And finally, probably we'll get to this next time, look at cyber torts, because the author had to sell a new edition of the textbook, so we have cyber everything. Right? Kind of an update to the textbook. I hope they never find out I say that. What are they going to do to me, right? Commit a tort against me? So, and watch, just a warning, watch out with your books. Somebody's stealing them. Like I've had students say that they'll stop in to a classroom or a library and they get their book swiped. So, you may not love it, you may not want to read it, but someone else wants to take it. I had a student who that happened to, but the college got them a new book. So I'm not saying go sell your book back. Right. So a tort is a private civil legal action to obtain monetary damages from a legal injury to a person or property. So there's a lot there. We were talking a little bit about it in terms of it's private means it's you versus me, or you versus the government. It's your private action against the government. It's not criminal, right? It's a civil legal action. And in tort actions, the primary goal is to seek monetary compensation for your harm, which could be a number of things. Notice it says legal injury. That could mean everything from broken bones to emotional distress to financial harm. So injury doesn't necessarily mean physical. And in some torts, that's not a requirement. Hint, hint. So when we talk about damages, we may be talking about everything from compensatory damages, which are to compensate a person for their actual harm. Like, let's say I slapped somebody in here. I don't know. Why would I slap somebody in here? Yes, I'm very angry that you didn't read the chapter and you were willing to admit in class that you didn't read the chapter. So I come over and I just punch you right in the face. Right? What would be your actual losses? It could be teeth, right? Nose broke. You know, those are things that happen to you. But money damages wise, what are you looking for? Medical bills, right? You have to go to the hospital. If I hit you, it wouldn't hurt. But if you went to the hospital and they treated you, you could get that. Time off from work, reconstructive surgery, whatever it is to return you. Maybe you're ugly and it helps. So whatever it is, you would seek compensatory damages for that. Potentially, there's some special damages listed up there in terms of wages that you might be out. But there's also kind of this whole aspect of, well, that's the physical damage that you suffered, but are there any other damages? Yeah.
Like emotionally embarrassed.
Right. So not every embarrassment, amounts to, earlier I was joking about somebody being ugly, and maybe they feel embarrassed, but the law is not going to give them a remedy for being embarrassed. But we'll get to intentional infliction of emotional distress. And if it can be established that this is just outrageous, then yeah, the law would recognize a remedy for that. And then potentially punitive damages, which is above and beyond actual damages. Anybody remember the Ford Pinto? You guys, maybe. It had a bad habit. What was it? It blowed up. Right? If you hit it from behind, it would explode. And so people sued, claiming, damage to the Pinto, damage to them. But Ford kind of came out in litigation, had this attitude that, well, now Ford's going to come after me, but let's wait and see. And through discovery, they determined that there was a part that could have been replaced and avoided the problem. And so the court said, well, we could make Ford pay, but to Ford, this is nickel and dime stuff. We're going to punish them. We're going to award damages well in excess of any actual damages, so they'll think twice before they make that kind of decision again. So those are the type of situations you get punitive damages. Don't just say every case you get punitive damages because the court wants to punish somebody. It's rare, right? Typically only available in intentional torts. Like if I run it around and just start punching everybody on campus, I'm just out of control. Maybe the court would do that. All right, so the idea is that there's a plaintiff, the person who's claiming that they're injured, complaining to the court, and the defendant, who I think just has the coolest title ever, tortfeasor. I want a license plate that says tortfeasor. The person who allegedly committed the tort injured the plaintiff, and they did it either intentionally, negligently, or it doesn't matter, they're just strictly liable for it. And we'll talk about situations where they're absolutely liable. Doesn't matter whether they meant to or not, they just are. So those are the three broad categories. And these slides go into detail about each type. The first is intentional, specifically intentional torts against people, because we'll also talk about property too. Now, I don't like this slide so much, and this is why. The author in the book and on the slide keeps saying assault and battery, which is certainly possible. Right? Even if you look at the definition, it says a battery is a completed assault. That's possible. My fist is coming at you for not reading your chapter, and then you're placed in reasonable apprehension, and then I actually make contact with you. That's an assault and battery. But isn't it possible that I could batter you without assaulting you? Verbal battery? No. That'd be another tort. How could I batter you without assaulting? Well, look at the definition of assault up there. When you're placed in reasonable apprehension, which means what? Apprehension? Right? Well, that could be a result of your apprehension. Fear. You have a reasonable fear that I'm about to make an immediate contact with you. Well, how could I make an immediate contact with you without you being reasonably fearful of it? Yeah, you don't know it's coming, right? So I could sucker punch you in the back of the head. There, that's for not reading your book, right? You didn't see it coming. You were never placed in a reasonable apprehension. It just happened. So you can have a battery without an assault, and you can have an assault without a battery. So I could stop short of hitting you in the face, and that would be an assault, right? Based on what I've told you, reasonable apprehension that I'm going to make contact with you. Now, they're all loaded words. You're going to find that with legal definitions. Reasonable apprehension. What would be unreasonable fear? Like you just come in, you sit down, you haven't read the chapter, and you're just really fearful I'm going to punch you. You have no basis for that. I've never punched anybody before that you know about. So, you could always be like excited or worried. You ever met somebody like that? They're skittish. Like, oh, something's about to happen to me, right? But that's not a reasonable apprehension. That's that person's subjective apprehension about everything. Of immediate contact. It's just about to happen. Well, what wouldn't be immediate? Like say I threaten you. If you don't read your chapter next time, because I'm sick of you coming in class and telling me you don't read your book. If you don't come in next time having read your chapter, I'm going to punch you. Let's say I'm really convincing in how I say it. maybe a reasonable person would be fearful if it was a risk of immediate contact. But what could you do between now and next week when you come into class? Read the chapter, I suppose. That kind of defeats the whole thing there. But then I couldn't punch you, darn it. What? Right, you could study up, come in all prepared, right? I watched the new version of Karate Kid. What else? What else could you do?
Tell the college.
Yes, you can let somebody know there's this nutcase who's really angry that no one reads the book, and I think he's going to punch me next time because he said in class, and he was being recorded at the time, I'm going to punch you. So you do something about it. So it's not an immediate contact. How about just not come to class? Then you'd avoid it, right? What if you're on the phone? You're in California, I'm here, and I say, if you were here, I'd punch you right in the face. And maybe it really upsets you. But I'm here, you're there. Are you actually placed in reasonable apprehension of immediate contact? No, I got to set down the phone, get on a plane, fly there, take a taxi, and then punch you. It's probably not going to be an immediate thing. You probably will move and avoid that by the time I get there. All right, so the words are loaded. Battery. One way of committing a battery, like I said, is completing an assault. It's coming at you. It does make contact with you. The other way is you don't see it coming, and I still enter into a non-consensual contact with you. Now, here's the one that will get somebody. Mark my words, it's coming up on the quiz and the final exam, but still somebody will say, I didn't say this. It's being recorded. It doesn't have to cause you physical injury. It's just a legally recognizable injury. So let's say you're in class, you're nodding off. I don't know how you could. This is such an exciting class. But let's say you're nodding off, and I'm like, I could punch him. But no, I'm going to wait for him to fall asleep. So you fall asleep in class. I walk over, and I slip my tongue in your ear. Wrong on so many levels. But my point is it an intentional act on my part? Yes. Is it offensive? Yes. Are your ears bleeding? No. You maybe got a little saliva dripping out. Maybe you wake up all startled or whatever, and everybody's laughing at you. But it doesn't require that I bruise you. The examples you often see is somebody's sleeping, and someone comes along and does something to them that violates their personal integrity. That's enough for a battery. I kiss you or whatever. If you didn't ask for it, then it's unconsensual touching. There's lots of examples of that. People who've been in dentist chairs. There's examples of situations where you don't know it's coming, so it's not an assault, but it is a battery because something happened to you that you didn't ask for, and it's considered offensive and under the law. Versus you're under in the dentist chair and your dentist is making fun of how funny you look or something. Probably not actionable. So I keep mentioning the whole idea of whether you ask for it or not. Let's look at the last two bullets. No motive is necessary. We're talking about civil torts. We're not talking about crime and motive. So if I come up and I punch you, and I intend to punch you, no one has to establish that I did it because I'm angry at you for something you did, right? I did it. I'm not supposed to do it. And even if I don't cause you physical injury, it may be sufficient to say that I caused you emotional harm. All right. When in the world, question or?
Don't most torts, they don't involve like assault or battery?
Most torts?
Yeah.
Well, I think some people think that because they're thinking at the same time there's also crimes involving assault and battery. But yeah, there's lots of torts around that. Somebody getting physically injured and it being done intentionally. Sometimes it's both, right? I mean, if I punch somebody for not reading their chapter, they could sue me civilly, recover the medical expenses, and I could be prosecuted criminally for doing that. When would you consent to be battered? Right. I mean, think of Jackass and all the other sequels to Jackass, the movie, right? All the situations where somebody, I could never watch one of those movies. Like one time I flicked and I saw one on and the guy was cutting himself with paper between his toes and his eyes and I was like, oh my goodness, I can't watch that, right? But, he can't then say, that person battered me because they sliced me with a piece of paper, because he just got through saying, do it. I remember being a prosecutor, and this is the criminal side of it, but I'd have people say, I was battered. Well, how did it happen? Well, I was at a bar, and then I said, let's go outside. And then I said, hit me. What did you think was going to happen when you invited the person to hit you? I didn't think they'd hit me. They did, didn't they? So, that's the criminal side of it, but yeah.
So if two people go outside,
yes.
Is that still illegal then?
Yes.
What would they get charged?
Yes. Well, criminally, battery or some other disturbance or some statute. Because, on the criminal side, the police don't want you even consensually fighting. They show up on the scene and everybody was kung fu. Everybody's in the parking lot beating each other up, and you can't figure out who's the good guy and the bad guy. You just start hauling people off. And then maybe they sort it out civilly later, but look at all the hands. Ooh, this is cool. I want to talk about this. Yeah.
Can the person who says hit me be charged for anything for enticement?
Enticement? I don't know what that criminal statute would be. Right? I mean, now we're talking about defenses. We're talking about situations where somebody asked or consents to have somebody batter them. So think about boxing. Sanctioned battery. So why should somebody be in trouble or charged criminally for saying to the other person, get in a match with me? Or why should let's say you pay pay-per-view. I don't understand this at all. I see these sporting events like Ultimate Cage Fighting or whatever, and people, how much does that stuff cost? So I'm thinking you must invite a bunch of people over and split the cost or something. But what if you pay big money and you're at home, and then the Ultimate Fighter comes out and punches the other guy, and the other guy goes, tort! And, says, I'm going to sue. No, they consented to get in there and have that done to them. Now, could somebody exceed the scope of that consent? Yeah. What was it, Mike Tyson, had an appetite for ears? Right? Who was it? Evander? Yeah, so he goes in there and he's like, we're going to box, right? He's not thinking, going to lose part of my ear. Right? So he consents to box, but not be chewed on. Another question? Yeah.
So if there's two people at a bar, and they both go outside, and they both say, hit me.
At the same time.
No, not...
Hit me!
What if someone's hit me, and the other guy's no, you hit me.
Right. Yeah, that's the way, usually when you're at bar, there's something else going, right, of course you do, because you wouldn't be asking this question if you didn't. But usually people are under the influence at the time this takes place, and their judgment is impaired. But yeah, all those situations could lead to a number of things. Civil actions by whoever sues first, and the other person saying, that's not what happened, and counterclaiming and saying, no, you battered me, right? To criminal actions where the police are the most common thing I would get in the prosecutor's office was, here's what happened. two guys fight over a girl. Just saying, this happens, right? And then I got a bar employee who says, I saw this happen all the time. And here you go, prosecutor. Good luck. Right? Here's my report. This is what all these drunk people tell me. You sort it out. Right? And then I'm looking at the report, because that, I wasn't there. So I'm going based on what the report is. And the report, I'm looking for little winks or, slants in the narrative to say, don't do anything with this. Or, this guy's a real jerk, more than likely. It's just, those are a challenge. It's, from a prosecutor's perspective, and again, we're getting off to the crimes thing, but it's better to commit and go with a defendant than it is to try to charge both parties with battery. Right? Because then they bring a bunch of drunk witnesses in. Well, they're not drunk when they're witnesses, when they come into court, but they were at the time. They're like, oh, no, he did it. No, he did it. Yeah. Anyway. So, back to civil torts. Also, the argument that you were defending yourself. So, you didn't say, hit me, but somebody tries to hit you, and you defend yourself. Or you're defending someone else. Or your property. You argue that I had to do this to protect my property. Generally, the law gives less protection when you're trying to protect your property. Notice these are defenses. These are the argument that, yes, maybe I did it, but my actions are excused. It's not an automatic thing. You have to establish either it didn't happen or maybe it did, but the law recognizes an excuse for this. So, I thought he was going to scratch my car, so I punched him. The law's probably not going to go with that one.
He's breaking in my house.
Right, breaking it, yeah. And then we can go down a whole different path of, maybe you punch people who are in your house at night. I'm not sure I would. Want to fight? In the movies they do, right? It's kicks and all that type of stuff. Me, I'd stand off at a distance. What's that? I'm not saying anything about what I would do. I'll tell you later, though. You got it. So, other intentional torts. So, false imprisonment. There's this idea, remember from past weeks when we were talking about that constitutional right to freedom and to move around, right? That we shouldn't have somebody restrain us unjustifiably. So in a business context, where that comes up the most often is trying to stop shoplifters. Anybody work in an environment or have worked in an environment where people steal stuff from them? Yes. So do you have policies about that? Like if you see somebody stealing something from a store, what can you do about it? You two raise your hands. Report it. That's the most common answer. Not confront them, not punch them, not restrain them, but tell somebody, period. Sometimes it's put in the context of let the professionals handle it. They've got extra training. But a lot of time it's like, we don't want any liability for it all. Let them run out of the store. Let someone else take care of it. Same thing with you?
Yeah.
Where do you work?
In Family Fair.
Awesome. I want to know where to go. Right. Yeah, because a lot of stores have that kind of policy. And it's for two reasons, really. Two big reasons. One is to protect their employees. If they don't want you getting hurt trying to stop somebody from taking a package of meat out of the store, it's just not worth it. Of course, there's a whole issue. They might have liability because you were an employee and you did something and got harmed. The other part of it is lawsuits by the person who says, I was embarrassed, I was harmed physically, I was restrained, I was falsely imprisoned, which means I was not able to go where I needed to go and there was no justification for it. Because then they'll be stuck in court trying to defend their employee's actions as to why that employee had reason to believe the person stole something. So a lot of these shoplifting statutes are, criminally are real specific about what's required, but also trying to protect merchants from these type of claims. I would see anybody work someplace where they saw odd things getting stolen? You'd be surprised what people take from stores. There's things that, if it's high value and it can be fenced, it's pretty, cartons of cigarettes, how much do they cost? 50, 60, 25, 30, I have no idea. But, just grab one of those. One of the most common things, which I thought was weird, was meat. That's why I mentioned it. Like, people would stuff it in their pants and walk out of the store. Why? Because they could sell it, get money, and do things with the money. Ever had that guy show up at your door with a truck full of meat and say, I got to unload these today, will you buy them? Anyway. The oddest case there was, this guy's walking out of the store, and like people knew that he would often shove meat down his pants and run out the store, so they were watching him. And as he walked by the clerk said, "Sir, stop, you're bleeding." And there's blood coming down his head. He's like, "Oh no, I'm fine." "Oh no, sir, look, you're bleeding." And he had meat stuffed up in his cap. All right, so infliction of emotional distress. Intentional infliction. Not you see something you didn't want to see and it really disturbed you. My son, he'll love me for saying this, projectile vomited the other day. It was awesome. I didn't know the human body could expel that much stuff that quickly. Sorry, I'm going to leave. But, that was very offensive to me. It smelled offensive, but it's not something actionable, right? So a lot of times on TV you hear that, I'm going to sue for emotional distress. Well, first of all, it has to be extreme and outrageous. A plane going down in front of you with your family members in it, probably yes. But the airline lost your luggage, probably not. Yeah, that'd be nice, wouldn't it? Some courts require physical symptoms. In other words, you can claim you have emotional distress, but you have to bring in evidence to show that that's manifested somehow physically. Hives, convulsion, I don't know what it is. An expert who testifies this is how he's physically manifested his emotional distress. But just saying you have emotional distress sometimes isn't sufficient. Defamation. You guys have probably heard of this. Slander before or libel. So, publication of a false statement, oral or written, that injures a person's good reputation. Again, see how loaded that is? There's all kinds of words in there that could be an out. Publication. From your reading of the chapter, what was required to have publication? Or you could just read the slide where it says publication. What do you need?
Third party.
Right, you need it communicated to a third party. So let's say before class, I stop you. My office is right across the hall, and I pull you in, and I say something really nasty to you. Wow, I just saw your quiz results. It's the lowest quiz score I've ever seen in my life. What is wrong with you? I wouldn't say that to you, but let's say you're really bothered by that. Is that publication?
No.
Why not? There's no third party there. It's you, me. I could say whatever I want and it wouldn't be publication. Now, I could put it out on the internet, even though you're not there, no one else is there, but it would be publication, right? Because other people would see that. What if I walk in here in front of an open classroom and say it? That would be sufficient, right? False statement. What if I walked in and I said, this person got this score on the quiz? Is that publication? Yes, I just said I walk in here, you're all here. But is it false? Maybe it's not. Maybe it's accurate, right? So one defense to defamation is I said something about you that was true. Now, it might be another tort, right? If I release information about you that's private, that might be another tort we're going to talk about. But it's not a false statement. So only when I say something to you that someone else knows about, hears about, sees, and it's false, and I do it to harm your good reputation. So what would be an exception here? Right, you don't have one. I mean, bad reputations aren't damaged. Only good ones are. So you have a bad reputation for that already, and I say something about it. Maybe it turns out not to be true, but everybody thought it was because you have a bad reputation for that in the first place. Fact versus opinion. This is intentionally representing something as fact that you know isn't true. If I offer an opinion about something, usually not. Like if I say, I think you're whatever, most people wouldn't consider that harmful. But if I said, you've been imprisoned for this, and then later I go, well, that was just my opinion. But that's a representation of fact, right? I mean, other people would think, he must have some knowledge of this. Slander, oral. When I say something about you, orally. Libel, written. Now, there can be a mix, right? Like TV. Don't you hear and see things on TV? Right? Or perhaps you're on the internet and you're reading a website and you play a video and you hear. I mean, it could be a mix of these things. But for our purposes, slander is oral defamation. Libel is written defamation. And, we talk about publication, but notice the last sentence there. Maybe you don't, in fact, know whether it's true or not, but you intentionally repeat something that is slanderous. You heard it, and you turn around and repeat it, and it's harmful to someone's reputation.
How does that work for, the magazine companies that publish all that stuff?
Right. So, sometimes, as I walk through the checkout lane, I can't help but notice these certain publications that seem to sell magazines or papers based on their headlines. What if they say Oprah has Martian baby? Someone's picked that up. Well, cool, I want to learn about that. Right? And most people are going to see that and know that that's not a representation of truth. They're going to know that that's entertainment. Now, there have been cases where celebrities have been able to recover for really nasty things that people have said about them. We haven't got to it yet, but if you're a politician or celebrity or some people who are often the focus of those magazines or papers, then you ought to know that people are going to say crazy things about you. And you're going to have to show they actually intended to harm you, actual malice. So in a lot of cases, they get away with it because it's entertainment, or it's not intended, or it's satire, or it's something else. Or maybe they just have good lawyers. All right, so in terms of damages, if something's in writing and it's not true and it's harmful, there's not a lot more you got to do about it. It's there, it's in print, you can't really take it back. You're liable. You're liable for libel. With slander, I might make some off-the-cuff comment one time. That's certainly different from me putting up a website where, people are drawn to it and I'm repeatedly saying something bad about you. Think about that in the business world. You ever seen those sites that trash companies? Like often they use the name of the company and you go there and it's, we hate this company because all these reasons. Well, potentially that's actionable. Here's somebody publishing things about somebody that might be harmful. And sometimes that can be a balancing, right? We should be able to speak freely, but what do we know about the First Amendment and what kind of speech is not protected? Wasn't this one of the ones that was on the slide? It was the first one. If you intentionally try to defame somebody, that's not protected speech. So you got to be careful about what you say when somebody's been charged with a crime or sells a product you don't like. But there's also slander per se, which means slander on its face. You hear this, it's just automatically bad. So here's some examples. Somebody says you suffer from some loathsome communicable disease. You know, they announce that publicly. Or professional impropriety. Or the next one, you come in and spread the word that I embezzled client monies and was imprisoned for it. Well, right there, the idea that I'm an attorney, but I take my client's money and embezzle it and use it for my own use, and then I was in prison for it, that's automatically harmful to my reputation and my company. And then the last one, I don't know so much these days, but the theory is that you could, men and women have personal reputations, and that you could say something that's harmful.
Like, do these have to be wrong, or even if it's the truth?
No, I'm saying, truth is still a defense. Yeah, this is, you shouldn't have to establish damages because everybody knows if you say this kind of thing and it's untrue, then it's harmful. But if it's true, like if one of you came in and said, I suffer from a loathsome communicable disease, like you talk like that, but you come in and you say that, and then I come into class, hey everybody, and announce it. The law would say, well, that's harmful. But what's the problem? It's also true. So it might be something else, like I disclose your medical history or something like that. That might be actionable another way, but it's not defamation because it's not a false statement. So we mentioned truth as a defense. We talked about public figures, whether that's stars, politicians, like the last round of elections. Oh my goodness, the nasty things that people were saying about each other. Most of that, free and open debate. We're going to let it go. You'd have to show that somebody actually started saying those things with actual malice. The one we didn't mention is the one in the middle, privilege. Sometimes there's a law that says you get to say bad things about people. Like on the floor of the Senate in open debate, you say something not so nice about someone else. In order to encourage that to be able to happen, you could have some qualified or absolute immunity to do that. So that's a statutory thing. There's some law that says you get to say that in this situation. All right, invasion of the right to privacy. Kind of moving on to that idea that, well, maybe it's not defamation because it's true, but it could be this, right? I mean, I disclose something about you that's private, that's not supposed to be made public. I intrude into your private affairs somehow. Identity theft is a tort. Portraying you in a false light. Maybe pretending to be somebody that I'm not might cause that person some kind of harm. The whole idea of the first one up there, a person has a right to solitude. Well, again, remember from the beginning of the course, no constitutional right's absolute. So we have some expectations of privacy in some areas, like where? Where would we expect that it would be private? Our home. Sort of. Like where would we expect that people shouldn't be peering into?
Bedrooms.
Right? Areas where we don't let them. Yeah.
So as like appropriation of identity, would be like what Facebook's gotten in trouble for?
No, I think Facebook has had issues with privacy. I don't think Facebook has pretended to be anybody else, or that other people. I mean, I'm sure there's people out there who are unscrupulous, have used consumer information to steal their identity and use, like, you say, here's my home address and phone number in your profile. Don't do that, by the way. And then they develop an app that rakes that information, and then they use it to steal. Yeah, that can be happening, but Facebook's getting in trouble constantly because they change a feature where they sell or otherwise communicate your private information to someone else without you opting in. Right. So, their first attempt was you say, I'm drinking a Coke or something on your wall, and pretty soon you're getting advertising. And that was because they would release, you had agreed as part of your account to release that type of information to others. And then this latest one was if somebody's put in their personal address and phone number, that marketers were grabbing the phone number without you knowing it and then calling you. Like if you updated your Facebook profile and somebody calls you, so as soon as they came out with that, everybody said, I don't think so. We'd like to opt into that kind of stuff. Which who's going to opt into that? Somebody might. I mean, what's a nice part about having your phone number in Facebook? Right, yeah. I mean, I got the iPhone app. I want to call somebody. I just pull it up. There it is. I call them. But, that's intended for that other person to have my information. Not everybody, including some telemarketer, to have the information. All right, appropriation. So this is kind of focusing in on that whole idea that you represent yourself as somebody else. Yeah.
That last slide, they're starting to send text to phones for advertisements.
Yes.
Is there going to be new laws for that?
Well, there are new laws around that, and just as soon as there are new laws, there are companies who develop agreements with customers to get around them. So right now, you get a whole lot of, you get a text, and it's from your provider, and they're telling you, no charge to you. Well, it's not because they're generous. It's because they got in trouble for texting their own customers and then charging their customers for the text they were sending to them. And then, maybe you get it from somebody else. My wife and I, we'd go someplace, and my wife would say, look, a free vacation. I'll just sign up for it. Well, pretty soon, text, right? They'd collect that information. They'd text you. And then if you said, why are you texting me? They'd say, because did you read? You said we could. So, yeah, there's always going to be that chase, like, no, we don't want you doing that. Okay, well then we'll ask if we can anyway. Like even in the laws that are relating to calling somebody over the phone. There are exceptions. We have an existing ongoing relationship. We're a charity. We're a political, all these things. All the folks who lobby have exceptions under the statute. All right, so this is zeroing in on that whole idea of you pretend to be somebody else. You appropriate their likeness. Like let's say I come in, I know sometimes when I'm going over these slides, you guys are like, oh, this is a little boring. So I come in an evening gown, and I flip over each letter one at a time. Dun, 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 dun. Who'd you think I was? No, you wouldn't. But anyway, you get the idea. Like I'm claiming to be somebody else. Now that you have that visual of me in an evening gown, you're waking up. All right. The one on the internet that is not really me, by the way. Fraudulent, intentional misrepresentation. You guys have heard of fraud before, right? So this is the tort of fraud. When somebody intentionally misrepresents something, and those are the elements right there, knowing misrepresentation of fact. Again, not opinion. I like to think of the used car salesperson. It's not the used car person saying, this is our best car. Who should believe that? But when the person says, this car has this many miles, and they know it doesn't because they rolled the odometer back, that's knowing misrepresentation of a material fact. Yeah.
They can do that? I don't know.
Oh, no, I'm saying you can't roll odometers back because there's a statute that says that's against the law, but it's also a tort. Right? And it doesn't have to be the person that rolled it back, right? I mean, you could be a salesperson, you didn't roll it back, but you know the mileage is inaccurate, and you failed to disclose it. Not just you represent that it has less miles, but you knowing that it has less or more miles, don't say anything about it. So you can get in trouble for fraud by something you don't say as well as something you do say. You should be disclosing a material fact and you don't, you can be in trouble. When a lot of cars down south got flooded, they cleaned them up, brought them up here and sold them. And that was one of the issues. Is if you sell them on the lot, do you have to wait for somebody to ask you, has this car ever been in a flood? Kind of reminds you of that Carfax commercial where they retype new upholstery, right? Do you have a duty to disclose that there's problems with the car or had been? Certainly, if you represent something as being something it's not, that's actionable. But some people claimed, well, not disclosing us that this car has been in a flood, that's misrepresentation too.
What if they didn't know?
Right. So, this is intentional misrepresentation. That's a good quiz question. Like, are there times where you could misrepresent something but you didn't know? Like, you could be selling the car not knowing that somebody who sold it to the dealership recovered it from a flood and fixed it up? Sure. So that would be unintentional misrepresentation. Now, somebody might still have a claim, but the argument that it was fraudulent and intentional, I don't think so. Like, you could be selling a car and say, well, this is the mileage it shows on the odometer, and not know someone else has rolled it back. So that wouldn't be intentional misrepresentation. I actually had a case, somebody asked that question. There was another student in class said, I'm a car dealer, and a guy came in one day looking for a van that had power seats. And I looked at the sticker on the van, brand new van, and it said power seats. So I sold him the van. He calls me up when he gets home. He says, there's no motor, there's no switch, there's no power seats. Now, why the guy didn't check that? I don't know. I mean, you think about it, like if there's a sticker that says it has it, are you really going to check everywhere to see if there's motors and switches? No. I don't know. So anyway, so he calls the dealership. He's like, you sold me a vehicle that says it has power seats, and you told me it has power seats, but it doesn't. He was right. It had nothing. Turns out the manufacturer made an error and put the wrong sticker on the van. So he misrepresented something, but he didn't do it intentionally. So that could happen. The other party, the innocent party, in other words, they're not involved in the misrepresentation themselves, justifiably relies on this misrepresentation. Like, what if I go to a car dealer and I say, is this car in good shape? And they go, oh, yes, it is. But then I take it to a mechanic who says, this is a piece of junk. But I go, yeah, it's still a good deal, I'll take it. Have I justifiably relied on the misrepresentation? No. Knowing that it's junk, I'm still going to do it. And then the last element, I'm harmed. What's the harm? I'll get to your question in a second. What's the harm in buying a car that has a lot more miles on it than I think it does? More maintenance? Less value, right? I pay more for a car that's really worth less. Yeah.
Question, well, you like saying this car's in good shape, but isn't that kind of just based on opinion?
Yeah, I think that I would need to flesh that out a little bit. Like if I said, boy, the car I got now has a bad transmission. What's the transmission like on this? And what the person says in response could be opinion, but more than likely, because I've zeroed in on that, is going to be a representation of fact. It has a good transmission. I mean, it'd be hard to come back later and say, knowing the person had a question about the transmission, I represented that it's good, and then later argue that's just my opinion. That's a tough one. But if I know that it's had things replaced or it's had problems, and I say, oh, it's good, then probably that's fraudulent. Yeah, so the whole good thing, like you look good in that, no one should really believe that. But, well, I didn't mean it that way. But You shouldn't rely on that. That's puffery. You're going to see that term keep coming up. Puffing up your product, saying things about it that people shouldn't really rely on. There's all kinds of commercials. My wife and I sat down and watched a movie together, which usually doesn't turn out well. If we watch chick flicks, we're good, but other than that. So we're watching this movie on TV, and a commercial comes on for the new Honda Odyssey. Right? So now there's the woman perspective first. Seats fold down, commutes to school well, can get groceries in it. Like the whole, this is what women do thing. Right? She's like, oh, brother. And then, what's the commercial that follows it? Anybody ever seen this commercial? The next one is the guy's perspective. The guy's an idiot. The only thing in the commercial is it's a leopard or something at first. And then, how'd you like my leopard? That's pretty good. And then fireworks, and then rock music. And that's the whole commercial. So the communication to the consumer is, if you're a woman, you're smart, and you are interested in all these features. But if you're a man, it just has to be, I forget what theme music it is. As long as it morphs from a Jaguar to a van, then you're good. I don't know. Anyway, puffery. Like no one thinks, oh my goodness, if I have this van, I'm going to hear rock music and there's going to be fireworks wherever I go. All right, negligent misrepresentation. It's possible that you say something about the car that you're not intentionally lying, but you really didn't investigate your facts well enough. If you had, you would have known that it wasn't accurate. Like it says in the second one, this typically occurs when you do have a duty to find out the information, but you don't do a good job of finding it out. So not everything is fraudulent or intentional, but still might be actionable. If I get a vehicle that has more miles on it than I thought, through no fault of my own, maybe there's something I can do about it. Maybe it's not actionable as a fraud, but shouldn't the guy who gets a van without power seats when he paid for it get some kind of relief for that? Yeah, get one that has it. But it doesn't mean fraud on top of that. He should get some punitive damages for it or something. All right. And this one, the idea that perhaps one type of tort is when somebody keeps bringing actions against you to harm you. So abusive process, that using the legal system could be another way. Or malicious prosecution. The government seems to constantly go after you. Let's focus in on business. It's possible that there is a contract between two parties and someone else comes along and tries to intentionally interfere with it. So what do you need in order to have this? How are we doing on time? What time is it? Okay. So you've got an enforceable contract between two parties. That's the first thing you need. Checking off the checklist here. Then someone else who comes along, knowing about that contract, tries to and successfully gets one of the parties to breach that contract. Now, that's different from a competitor is selling a product and one of the parties of the contract willfully breaches it and goes with a competitor. Right? There's competition, and then there's the parties to the contract on their own deciding that they want to breach a contract. That's not this tort. This tort is somebody else, knowing there's a contract, getting one of the parties of the contract to breach it. Question? Or?
There's a situation like that, I don't know if you've heard of, Orange County choppers, but,
I'm guessing it's in California, has something to do with motorcycles.
in New York,
Oh, Orange County.
yeah,
In New York?
yeah.
Really? Huh.
They
Learn something new every day.
hired a guy, and then, the father and son split up and started their own shop, or he started his own shop, and then the father hired a guy, a manager, and then the son hired him, and then they got a bike built from a company that he had prior
Yeah, which is separate,
Yeah.
right? That's suing the son and that company for breaching a no competition agreement. We're not talking about the guy with the long mustache, right? That's who we're talking about.
Yeah.
Musclehead and his dumb son.
Mhm.
Just kidding. I don't know how they're going to come and hurt me. But yeah, I mean, it's the whole idea is that if we split, then we're going to enter into a contractual agreement whereby we won't compete directly with you. And what does that mean? Usually in the contract, it means not taking an existing client to the new business. But that's different than this. This would be like, and maybe this is what you're saying, like Dad has an ongoing client, and he has a contract to build a bike. And then the son, knowing about it from when he was there, gets that client to breach that contract and come over and contract with him. I don't know if that's the same thing as you're saying. It sounds like you're talking about a separate contract, a non-compete contract. Same scenario, basically, but it depends on what tort you're claiming here. Or in your case, that wouldn't be a tort. It'd be interesting to find out exactly what it is, or if it even exists, or if it's just a TV show. But whether it's a tort of this, or whether it's an alleged breach of contract, which is not. Do note that we're going to get to contracts. We're going to spend like 3 chapters on it. These two are separate. You could have both, right? I mean, you could have like a mix of these things. You can even throw in crime if you want. Not that I'm saying there's a crime involved there, but it could be multiple things. All right. But even if there's not a contract, let's just say in that scenario, if the son just keeps saying and doing things to harm Dad's reputation in the bike community, then maybe Dad brings an action alleging that even though I don't have a specific contract with these people, I have worked with them before, or I plan on working with them, and the stuff you're saying about me is so bad that it's interfering with that relationship. I'm not saying that is at all what's happening. I'm just using that as an example. So, in order to prevail, then you'd have to show that that's part of some intentional plan, not just competition. I mean, those type of situations. I mean, there's all kind. Let's get away from the chopper context. There's all kinds of things happening in other businesses right now too. Companies splitting, going off their separate ways. CEOs getting fired from one company and then working for the competition. You know, then there's all kinds of these issues come up. One defense is it's just competition, but I guess it depends on how far you go. All right. Probably won't get through all the intentional torts against property, but we'll keep going until we're out of time here. Trespass, you guys probably think about in the criminal context, but this is the civil side of it. There's a tort called trespass to land. And it means a variety of things. It means going on land when you know you're not supposed to be there. It means going on land even though you don't know you're supposed to be there, being asked to leave and not leaving. It could mean not you going on the land, but you putting something on the land. That's where this kind of goes past the whole idea of the criminal trespass. Let's say I'm going to build a pool behind my house, so I dump tons of sand into my neighbor's yard. Like my neighbor comes out, what are you doing? Well, I'm getting ready to put in a pool. Okay, but now I can't use my backyard. Even though I haven't went on his land, I've interfered with his right to use his land, and that's actionable. So actual damages, in that case, maybe I damage his grass and whatever by putting sand on it, but that's not required. As soon as I interfere with his right to use his land, that's sufficient for trespass. Yeah.
Well, there's like a case where there's a lake in back of a house, like in some kept land in plane on it, wouldn't that interfere with someone's right to use the land underneath the lake? Or it wasn't their land because you never touched the land.
Well, I think in any case involving air, it can be tricky. Right? Because, I mean, that's a good point. As I say, trespass to land is interference with someone's right to use the land. It doesn't have to be me dropping gravel over it. You know, if a plane keeps flying through my backyard, you know, below the level of the roof of my house, then I might say that's kind of interfering with, you know, I send my kids out there and zap, you know, they get hit by a plane. Or, you know, I got to watch planes go by my window every day. You know, this could be a problem. So the whole idea that something comes over your house and lands in a lake, maybe more an interference with your right to use your land or it feeling like it's a nuisance. I don't know so much about your right to use the land under the water. I mean, water could be considered yours too. I mean, there's a difference between a lake and a pond behind your house that belongs to you. And somebody keeps landing there because they think it's water they get to. Yeah.
So then what about oil that's underneath it?
What about oil?
It's not really on the ground, or like it's really deep.
Well, so let's say I start going next door and tapping into my neighbor's oil below his land. He's like, "What are you doing?" I'm like, "I'm not interfering with your land. I'm just getting the oil out below." Right? Well, that's still trespass. So we get into talking about what is real property, but the minerals below your land, the surface of your land, and the air above your land are yours. Not absolutely. Don't start shooting down planes that fly over your house, but you have certain rights to them. So unless that person has a right to go get that oil, then that'd be a problem.
Now, what if it was in their land and then it ended up in yours?
I mean, out by my house, gravel pits, right? Companies pull all the gravel out of the land, or they sell off the land, and they want to reserve the right to come back onto the land and take stuff from it. And then people are like, "What are you doing here?" "Hey, look close. We sold you the surface rights, but we, retained the subsurface rights." So sometimes that is the issue. You claim trespass, and they claim, no, a defense to trespass is consent. You gave consent when you let us come in and take the water, oil, gravel. Are we out of time? How much time? 10 minutes? Awesome. Right. So, some people think by default they get everything. But look close. Somebody grants you some interest in real property. How much is it? How long is it? Maybe it says forever, but only the surface. We reserve an easement and a right to come on your land and do this. Or to fly over it, or whatever it is. To have lines over it, or lines buried under it. So yeah, there's all those defenses. Trespass to personal property. This is a good one. This is kind of the tort civil side of stealing. It comes up when you wrongfully take or interfere with someone else's right to use their personal property. So let's say I snatch your book. There's a crime of larceny, but we're not talking about that. We're talking about my intentional interference with your right to use your book. I was talking about that at the start of class. That is trespass. Not to your land, but to personal property. Okay? So when I interfere with your right, see, the point here is it may not be indefinite. Like the whole idea of larceny, which we'll get to, is taking with the intent to permanently deprive someone. I might just interfere with your right to use your personal property for a period of time. That'd be enough under the tort law, if you can establish there's some kind of damage for that. All right, conversion is a little different. And the book I don't think does a good job with this one. Because it almost seems like these two are the same. And you're going to see it coming up soon. So conversion is a special tort that's designed to get at converting the use of something that wasn't originally yours. Notice how that's different from what it says. It says wrongfully taking or retaining possession of chattel, which is personal property, and placing it in the service of another. Well, yeah, that's one way to convert. All right, let me give you an example. You know, my driveway was all snowy this weekend. I go next door and I ask the neighbor to borrow his snowblower. Why would I do that? To blow out the snow on my driveway, right? So now I keep it. You know, finally the neighbor calls the police. Never got my snowblower back. The police show up at my house. They're like, we're investigating a report of a stolen snowblower. Did I steal it? No. I mean, my defense, my argument, both in crimes and in tort, is I lawfully got possession with it. But if I convert it to my own use and keep it, sell it at a garage sale, commute to it on work, maybe it's a riding snowblower. Those are all things that are contrary than that person's interest in the property, right? So my wrongful taking there is keeping it and using it some other way. My retaining possession of it and using it in a different way. That's the conversion. Converting it to different use. I could also modify it, right? Let's say in the summer I asked to borrow his riding lawnmower, then I soup it up and race it up in Cedar Springs, right? Because that's what they do up there. That's wrong. Sorry, but that is converting it to a different use. Often combined with trespass personal property, I interfere with your right to use your personal property because I may have borrowed it to start with, but then I convert it to my own use. All right. I could also say, we'll end on this one. That doesn't mean fold up and don't listen to me, but I don't want to go any further than this today. You could slander somebody's stuff. Not just them, but their property. So I could say something bad about somebody's title or the quality of their title. For example, let's say you own property and you go to sell it. But when you go to sell it, there's a lien on it. The lien is wrong. What does that do to the value of your property? Drops it. You can't sell it. Or if you do, you have to pay to have the lien removed, right? So this comes up sometimes. You know, I have a claim against somebody, and I hire a lawyer to file a lien on their property. And they mess up and they file it on the wrong piece of property. Whoever they file it against has diminished quality of title or a slandered title. So this could affect property too. All right. Next time we'll pick up with negligence.